The first point is with respect to appointment of an arbitrator. Section 10 of Indian Arbitration and Conciliation Act 1996 talks about the appointment of arbitrator by parties and courts. Schedule 4 talks about the fees payable to the arbitrator, and Schedule 5, which is the most important and sometimes become contentious, is the disclosure of relation of an arbitrator to the parties. The Schedule 5 is important because sometimes if the arbitrator fails to disclose the relation between the parties, if he has any, then it becomes the ground for the removal of the arbitrator and the award can be set aside. The second part is about the duration of proceedings. Unlike the Arbitration Act 1940, 1996 in the recent amendments have put Section 29A. The Section 29A limits the time for the hearing and the award to be published. The total time which has been given as per Section 29A is 12 months from the date of reference, and this 12 months can be extended by 6 months by the mutual agreement of the parties. Coming to the third part and the important part is the interim measures by court. Interim measures of court is defined under Section 9 of Arbitration Act, and the interim measures means where a party has to seek immediate relief and where its interests are getting hurt, and if this immediate interim measure is not attained, then it can go to loss or even can become bankrupt. So during the proceedings, during the arbitration proceedings, or even at the time of publishing of award, the parties can approach court and seek for interim measures. Similarly, Arbitration and Conciliation Act 1996 has given powers to the arbitral tribunal also to provide interim measures. This interim measure is provided under Section 17 of the Act. Again, the ground is same, that if the party thinks that its interest is getting hurt and if it does not get the interim measure immediately, then it can lead to serious losses or even lead to bankruptcy. The Act has been very cautious, and it has said that any such interim measure passed by the arbitral tribunal will have same power as of the court of law under CPC, Civil Procedure Code. So any interim measure provided by tribunal under Section 17 is equally enforceable as any order given by court of law. Fifth point, and the very important point, is equal treatment of parties covered under Section 18. Section 18 says that arbitral tribunal should give equal treatment to both the parties, and the parties should have full opportunity to defend their cases. It is important because sometimes the party in front of Union of India argues that the methodology adopted by Union of India or some sections or some arguments are untenable and cannot be entertained, but this is wrong. Section 18 can be invoked in such cases or in such arguments, and Union of India should equally and with full force should defend their cases. Last but not the least is the competence of tribunal. Competence of tribunal is covered under Section 16. Now, what does it mean? Competence of tribunal is very important concept in the Arbitration Act in Section 16, which says that the jurisdiction of the arbitral tribunal as well as the admissibility of the claim, if there is a dispute on these two issues, the tribunal itself has the power to decide whether it has the jurisdiction to decide certain matter or certain claim is admissible or not. The tribunal itself becomes the judge of its own dispute or contention of the subject matter. Why it is so? In order to reduce the litigations approaching the court and the matters are resolved at faster track. The contention under Section 16 is that if the party has applied for any dispute with respect to the admissibility or the jurisdiction, and if the prayer gets rejected under Section 16, then the remedy lies only and only under Section 34. Section 34 is applicable after the award is published, and the prayer has to be put that arbitral award needs to be set aside. So this section 16 is very tricky. If the Union of India, whenever we are defending any case and we think that certain claim is non-admissible or the tribunal does not have jurisdiction to sit over certain matter, then it is better to use either section 17, which is interim relief by the tribunal, or section 9, interim relief by the courts, because if we go through section 16 and the prayer is rejected, then the only remedy lies in section 34.